State of Washington Court of Appeals, Division 1 is now in session. The Honorable Cecily C. Hazelrig presiding.
Good morning. Please be seated. The first case on this morning's docket is Scott versus Amazon.
Thank you, Your Honor. But before I begin, I believe there was a motion that was granted by the clerk's office to enlarge the oral time requested by plaintiff respondents, requesting 15 minutes. I might be mistaken about that, but I thought they granted the motion.
Okay. Yep. So
I apologize in advance for subjecting y'all to 5 extra minutes of me.
or making me do math, which is the bigger problem. How much rebuttal time?
If I could reserve that extra 5 minutes for rebuttal, I would appreciate
Understood. Okay.
it. Thank you, Your Honor. May it please the court, Greg Miller of Perkins Coie LLP on behalf of petitioner Amazon. The facts of this case are indisputably tragic. As the father of 2 young children, I can't imagine what it's like to lose a child, much less to lose a child to a tragic act like suicide. This case arises from 4 individuals, 3 young adults, and 1 17-year-old who carried out premeditated plans to commit suicide over the course of several days or months using sodium nitrite, which they purchased on Amazon.com. While the facts are tragic, tragic facts are not a basis for imposing liability under Washington law. They were not a basis when 8-year-olds were catastrophically injured in Bonn on a mini trail bike, not when a 16-year-old was paralyzed on a trampoline in Anderson versus Weslow, and not when a baby was injured in a mobile walker in Thong Chum. A 3-judge panel of this court has already recognized as much in an order joined by Chief Judge Smith, along with Judges Feldman and Burke, that on a motion for reconsideration rejected the same arguments that plaintiff respondents are presenting here today. No court in Washington or in any state has adopted the novel duty that plaintiffs urge on this court here. And there are fundamental, long-established bedrock principles of tort and product liability law, which are embodied in the Washington Product Liability Act, that preclude this court from adopting them here today. The
Counsel,
first,
can you address the issue of whether or not the Product Liability Act only allows claims against a seller when a product is defective?
okay, so there's a red herring that the plaintiffs have attempted to place on our arguments. We have at times used the word defective as a catch-all, but if you look to the common law prior to the adoption of WPLA, there were a suite of duties that were imposed on sellers that related to the safety of the product. A duty to inspect, to see if there were potential defects that the seller might be aware of, and a duty to relay warnings or instructions. Those common law principles were the background on which the legislature legislated and informed the plain meaning of a legal phrase like negligence.
But how does that mesh with so the product liability statute sort of subsumed the negligence claim, but of those things that it lists in the statute, it talks about marketing, negligent marketing. How does that jive with your argument that there has to be some sort of defective product or safety issue with the product?
Well, so negligent marketing would fall under the warnings and instructions that are not relayed by it. But if you notice, the sweep of the definition of Product Liability Act is also broader than the actual actionable items that you are allowed to bring claims for. Like you have to have intentional concealment. Like negligent concealment is not a cause of action, particularly against sellers under the Washington Product Liability Act. And I think to kind of step back, and it's important if there's sort of ambiguities here.
Can negligent marketing be something unrelated to warnings? In other words, could you market something in such a way that could cause harm to people or enable people to cause harm?
So there is one Washington Court of Appeals case that I think was then vacated on remand. There's no case that has addressed negligent marketing, but I believe that case held that there was no claim for negligent marketing because it was passed out by the act. But Even if there is, I think getting down into the weeds on that is not necessary to resolve this case, because the preamble, the textually adopted purpose of the Washington Product Liability Act is supposed to reserve claims where there is an unsafe product. It is not meant to go beyond and allow there to be claims that are based on obviously dangerous misuse of the product. That has never been the case in Washington. And most importantly, it has never been the case when it comes to suicide. Proximate cause had a well-established legal definition at the time that the Washington Product Liability was enacted, not only at the common law, but it had also been reflected in legislative policies, which are not addressed by the other side, that reflect that same basic principle, both in the Industrial Insurance Act and in the code dealing with insurance, which are the two instances in which suicide most likely comes up, and you would see the legislature legislate. And the judgment that was made is when you have voluntary conduct, that liability falls on the individual who has deliberately killed themselves, unless you can in some way say that the defendant's conduct inflicted the mental state itself.
So counsel, I have a question about that. So you're referring to Arsnow and Orcutt. And of course, Arsnow was 1930s and Orcutt was, I think, 1961. And both of them rely on the restatement of torts. And of course, in 1963 came the second restatement of torts. And with that came this sort of an enabling tort idea. And a lot of states have sort of adopted this enabling tort idea over the old restatement idea of superseding cause. Given that, do you think that our Supreme Court would decide Arsnow and Orcutt the same way now that the restatement second of torts has come out with this idea of an enabling tort? Do you think they would decide it the same way?
So Section 455 of the second restatement also carries forward the deliberate act principle. And so I would say that it was not sort of overruled or in any way kind of like done away with in the second restatement, and has been reafirmed by.
I'm not suggesting that it was.
But yeah, but the answer,
I don't think the
short
Supreme
answer,
Court has revisited it since then. So do you think they would have a different view of it now?
they might well, especially in a common law context. That is certainly not this court's province to be reconsidering, because the gravamen of that rule is based on the voluntary nature of the individual's conduct, and they're absent a special relationship. There is no duty of care for defendants under Washington law to account for the intentional conduct of others, unless they have been entrusted to your control, like a jailer or a hospital or another custodial institution that is charged with that care and has the ability to monitor and sort of continuously exercise control over you. But
can you respond to the aspect of the special relationship argument addressing a protective duty between a shopkeeper and an invitee?
okay, so, and I think this will also get back to your second question, Your Honor. Even the Washington Supreme Court can't overrule that rule insofar as it is embodied in the Washington Product Liability Act. The proximate cause element has the same meaning that it had on the backdrop of common law when it was adopted, and there's no room to change it, which then goes into your question. The Washington Product Liability Act precludes creating novel special relationships between the purveyors of products and the purchasers of those products. And then you kind of look at the general what they're asking you for now is that there's a special relationship anytime anyone even steps onto a digital premises to purchase products, where there has to be an accounting not of the danger from third parties injuring them while they're on the premises, which is what that actual duty is. And the court recently in the Barlow case, the Washington Supreme Court re-emphasized that they were not going to extend the special relationship beyond its existing bounds to premises owners and the physicality of a university campus. But you would then have a continuing duty. You have to account for misuse of the product. And that feeds us back into where I think bond and product liability principles reinforce the applicability of the general negligence rule with regard to suicide, is that obviously dangerous misuse has never been considered to be the responsibility of manufacturers or sellers. And you can just imagine.
I'm sorry.
To some extent, it seems as if plaintiffs are saying the only purpose for this in this small bottle, 96 to 99% proof, would be for someone to use for suicide. And so that makes it different than just misusing a knife that you purchase on Amazon?
Okay, so first of all, not squarely on point. The idea that a court can declare that there is no legitimate use for a product is effectively a legislative act, and it's not really the province for negligence actions. We deal with that some with the California cases that are cited in the negligent entrustment argument in the reply brief.
Well, this is a
as well.
12B6 argument. If it's alleged in the complaint that that was the case, then don't we assume that it's true for purposes of 12B6?
Well, they cite the FDA reg. They make allegations too that there are a number of legitimate uses, both in the laboratory and the industrial context. They also cite an FDA regulation which recognizes that there are household uses and puts label warnings for children when it is sold in a package where it's meant for household use. So they argue that there are legitimate uses, and Amazon does not distinguish between where it's delivering. It does not have a list of industrial and laboratory addresses and home addresses. And there is no requirement under Washington law or under.
So let me ask you this. So there's, with regard to the sort of dram shop cases or the selling of a gun to an obviously intoxicated person, those kinds of things, if there was evidence that Amazon knew that there were vulnerable people that were purchasing this product in the same way that you would know that you're selling a gun to an intoxicated person, if that were the case, and if there were facts supporting negligence in the way that was marketed and promoting the product to be used for that purpose, then would you agree that that Bernathy in that line of cases would apply?
Well, I don't want to fight the hypothetical, but to go to the question of, I don't know what a vulnerable person is. They don't really define it. There's no set age category. There are no markers. And I would refer you to the Melee versus Turner case by the Supreme Court, where they said there needs to be obvious physical or mental manifestations. There is no, quote, duty to inquire as to the competency, unquote, of the entrustee, which is really what they're asking here, is profiling and projecting, are these people incompetent based on a profile that you can gather?
Thank you.
Good morning. May it please the court. Phil Talmadge here representing the families of the respondents. As have multiple other trial court judges in this case, the trial courts here correctly denied Amazon's 12B6 motion to dismiss the family's complaints arising out of Amazon's facilitation of the suicide deaths of young people by supporting and promoting sodium nitrite, an industrial strength deadly poison with no household use. These vulnerable young people used it. Amazon knew that this poison was supplied from its website. It knew that it was being used for suicides. It knew that regulatory authorities were concerned about that. It knew that it was banned in places like the Netherlands. It knew that there were New York Times stories about this problem that was occurring. It knew that Congress had sent a letter to its CEO saying that this was a problem. It knew that Ruth Scott had approached Amazon and said, this is a problem.
So let's talk about.
And nonetheless, it
let's
sold the
talk
product.
about your arguments with regard to duty.
Yes, ma'am.
Because there are myriad products that are sold across the country that can and have been used in suicide. What is the outer limit of your proposed duty to sellers when we're talking about an item that can and has been used in such a way?
The duty, Your Honor, is very simple, and it's rooted in the Washington Product Liability Act itself, and that is under 040 seller liability, it's negligence or intentional concealment and misrepresentation regarding the product.
Right, but you, in briefing, you're asking for specific rules. One of them, you indicate that you think that we should create a rule that says that sellers have a duty to refrain from supplying a deadly substance to consumers whom they know would likely use it for lethal ingestion.
Which is the standard in Restatement 281. As our Supreme Court has adopted in Beltran-Serrano, you have an obligation, a duty to refrain from engaging in conduct that enhances the risk that's foreseeable in your interactions with others. That's the essence of 281 and what Beltran-Serrano, Mancini, and other decisions of our Supreme Court have said. The bottom line here is in response to your question, Judge Hazelrigg, the question about defect, pre-existing Washington law, Tabert, adopted seller liability under 402A.
So before we go there, let's back up for just a second. Let's presume for a moment that there is a duty, that the duty was breached.
Correct.
How do you propose that we deal with Arsnov and Orcutt, our Supreme Court cases that talk about superseding cause?
I think that's a perfectly appropriate question, Your Honor. And to your point, I think that those decisions arise under a peculiar set of facts. In those circumstances, the plaintiff is injured. In the course of the activity of the plaintiff thereafter, they develop mental health problems, and those mental health problems result in individual suicide. It's really something of a superseding cause kind of analysis, I think, that those cases originally tried to address. This case is different.
Well, I know that in the restatement at second, of course, they started to move toward independent superseding causes rather than, something, if the negligence is within the scope of, or foreseeable that it would cause the problem, then it can't be a superseding cause. These cases seem to run contrary to that. Is that something that's just specifically unique to suicide, or is that something you think was there because of the timing of those cases?
I think it's unique to the circumstances of those cases and probably the timing as well. But those certain cases, again, did not arise in a circumstance where the suicide was the wrongful conduct. What we're talking about here is Amazon provided the instrumentality of these kids' death, knowing that it was doing so, knowing that it was marketing that deadly product which was irreversible. It was an irreversible poison, as the facts of these cases demonstrate. It knew that it was doing that, and notwithstanding the fact that it knew that it was doing that, it continued to do it. The suicide deaths of these kids was the intended result of the wrongful conduct. So under our case law that deals with the issue of superseding cause, which itself is a question of fact ordinarily, this is not a different type of harm or something that's completely unexpected from the circumstances of the wrongful conduct. It's a natural sequelae of the wrongful conduct of Amazon. The provision of these instrumentalities of death, the facilitation of suicide, is different. Washington law, there's a statute that specifically makes it a crime in Washington to facilitate suicide. So you have that element that makes this kind of case completely different. And it's also what makes it different in terms of Webstead, the case that they've harped on for so many years. Division 2 case, split decision of that court, 2-1. It's a case where the former county executive down in Pierce County was in a romantic relationship with the decedent. And in the course of that romantic relationship, they had a falling out, and he was less than honorable in failing to come to her rescue to prevent her suicide. But it's a prevention of suicide case. It's not a facilitation of suicide case. It is not a case where you're marketing the product designed to kill people. And that's what Amazon did here. I don't want to put too much of a gloss on it for all of Mr. Miller's concerns about his, the circumstances and how tragic they are. Ruth Scott came to Amazon and they didn't have much of a response to her when her child died. The point here is this was a case where Amazon knew what it was doing. It knew that there were all these problems. It knew as early as 2018 that sodium nitrite from its website was being used for suicide.
So would this be different, my hypothetical, if the sodium nitrite was purchased by someone else in the family for some other reason, and then later on someone who is suffering mentally decides that they want to end their lives and they go and get that? Is Amazon still responsible then? And if not, how do we parse that out?
Well, I think it all falls, and your hypothetical is a solid one, Judge Smith. I think under those kinds of circumstances, there's a significantly lesser chance of liability on Amazon's part under the circumstances because the chain of causation is different. It's something that you then analyze in terms of intervening cause and all of those kinds of analyses and decide, is it within the chain of causation that you would expect? The cases like Campbell and Albertson, this court's unpublished decision in Pamplin were all cases involving, is it of the same ilk? Is it of the same type of harm that you would expect? And the difference between your hypothetical and this case, these facts, is that Amazon knew. It knew that there was a problem. It knew that it was providing this deadly chemical to young people who are vulnerable, and they used it. And that's the differentiating factor. When there's somebody else in the mix, somebody that's a wild card, so to speak, That's when you get into the superseding cause kind of analysis. And probably the argument that they would make at that point is traditional superseding cause principles. This isn't that case.
So it sounds like, at least with regard to the negligence claim, you're really arguing, look, this is an enabling tort theory, right? So they're facilitating, they're enabling, and they knew. In the enabling tort types of cases, like the dram shop cases and the gun cases, you are present with somebody and you're able to see them. And so you can see that they're intoxicated, you can smell it, you can judge it with your own eyes. Here, there's the allegations of the complaint are that Amazon knew, and they knew because they knew this website was sending people to Amazon, presumably vulnerable people to Amazon. They knew from their interactions with foreign countries that it was being used for suicide. They knew for all of these other reasons. But is it significant that that is kind of knowing in a general way rather than knowing a specific person?
I think it's enough to know in a general way. And of course, we're dealing here with a 12b6, so there has to be no set of circumstances, factual inferences from the facts, hypothetical, beyond a reasonable doubt that there's no cause of action. Under 390, there's a cause of action, and all you need to do, Your Honor, is look to the Hickel case. Hickel is significant because that's the case in which there were organic wastes that a particular agricultural firm over in Eastern Washington was providing, and the property owner was just basically digging pits and throwing all this stuff into the pits, and it was just a toxic brew. They didn't have to be present to be liable, and that's what our Supreme Court determined in that case. Hickel is particularly important, in addition to Bernathy, where you have the obviously intoxicated individual that the gun shop owner sees. In that particular case, you had the agricultural producer who knew, who had an awareness that this farmer that it was giving all these chemicals to was dumping these chemicals in a way that somebody could fall into them, and the plaintiff did.
Counsel, how do we square your argument a moment ago about it's being enough to just know in a general way with your arguments with regard to special relationship?
Well, Your Honor, we've argued a facet of special relationship. The Nivens case is a business invitee case. We've suggested to the court that, under business invitee principles, Amazon invited all of these people onto its website. It is no different a physical business than a virtual business. They invited them onto their website. They have a duty under the principles of business invitee.
Have any authority applying that case to a digital online context?
No, and it's an extension. I concede that, Your Honor. But Nivens is a broadly written case, and it speaks in terms of business invitees and counsel.
And premises in danger from third parties.
Yeah, and
criminal conduct, correct?
Right. It's a criminal conduct case. It was a guy walking through the parking lot in that particular case. But the one argument that counsel has raised in opposition to that is the Barlow case, which is not even apposite. I mean, we're talking about a case of premises liability. The Washington Supreme Court recognized that universities have a premises liability obligation to invitees to the premises. The question is, what is the premises? And we've not had an opportunity in any case law to decide what that is. Regardless of whether a special relationship exists, however, there's a duty present here. And let me, in my short bit of time, talk a little bit about the defect issue and about the WPLA and their tortured analysis of the WPLA, something with which I'm fairly familiar. In terms of the defective product argument, Tabert said prior to the existence of the WPLA that you don't have to prove a product defect to establish a claim under 402A. That was the case that adopted seller liability, strict liability for sellers in Washington. That was what the legislature was trying to deal with in 1981. The legislature did not want to apply strict liability to sellers in the chain of marketing of a product. And that's what 040 was designed to address and did. It said negligence or intentional misrepresentation or concealment. What counsel wants you to do is he wants you to import defect into the language of the WPLA when it doesn't exist there. It didn't exist under pre-WPLA law in Tabert. It doesn't exist anywhere in the language of 040. It doesn't exist anywhere in the expansive legislative history of the statute. It doesn't exist in my law review article contemporaneous with the adoption of the statute in 1981 because it isn't there. There's no requirement of a product defect. So turning to the WPLA itself, counsel wants to qualify what the legislature said, and he's in desperation, they're reaching for all sorts of different kinds of pieces of the statute. The plain language of the statute is a seller is liable if they're negligent, period. End of point. It's not qualified by product use. It's not qualified by common law. It's not qualified by anything. It's negligence. And you, in interpreting a term that is a term of art in the common law, negligence, you assume that the legislature understood what that meant, and you assume that the common law definition of negligence applies. That's what the Schwartz case said. That's what the Supreme Court said in Potter. So you would apply the common law as it developed. What the legislature was doing was establishing a placeholder, and it said negligence is what applied. The WPLA used the Model Uniform Product Liability Act of the United States Department of Commerce in many instances. In Section 105, seller liability, it departed from 105. 105 qualified seller liability. There was a screening mechanism in that statute. Legislature didn't adopt it. There was a discussion of negligence, lack of reasonable care with respect to the product. It was specifically tied into the product. The legislature didn't adopt it. Negligence, period. That's what it said. So all of counsel's arguments about, oh, you can't do this and you can't do that about duty, plain language of the statute, plain language of how the court interprets the common law. The fact that the legislature itself in 020 sub 1 said, we're not changing the common law as it existed, except insofar as that we specifically do so in this statute, consistent with the usual rules of interpretation of statutes. It's the way that works. Our interpretation of the duty here is the correct one. It's the one that Commissioner Johnston appreciated at the Supreme Court level. It's what all these trial court judges have found. And when you look upon the standard for a 12b6, Amazon should not have, these trial judges got it right. We ask that the court affirm the trial court's decision here to deny Amazon's 12b6 motion. Thank you.
Thank you, counsel.
Thank you, Your Honors. I'd like to just make a few quick points. First, starting out with one of the questions from the panel is, what is the outer limit of the plaintiff's theory? And the answer is right there in pages 19 and 20 of their response brief. No test, no specific standard, no specific factors. Basically, any harm that is foreseeable that comes from
Well, let me push back a little on that. Would you agree that there's a duty not to knowingly enable another to cause foreseeable harm?
No, I'm not aware of any duty that's enabled, especially in the context of the sale of a product.
What about the dram shop cases? What about Burnett?
There's a specific common law duty, and if you read the cases, the duty kicks in when someone is inebriated, where they're effectively a helpless individual, particularly in the dram shop.
So it's a duty not to knowingly enable another to cause harm, but the knowingly enable means for some reason this person is likely to cause harm with what you're giving them. For example, you're giving them alcohol when you know that they're drunk and they go out and kill somebody. There's liability for that. You know that somebody is drunk and you give them a gun and they go shoot somebody. There's liability for that. So isn't that the duty?
No, absolutely not. There are defined duties when it comes to the sale of a product, and Bernathy dealt with inebriation, which existed as a common law duty prior to the adoption of the WPLA, and Melly versus Turner gives you the answer on 390, is there needs to be observable, objectively manifesting incompetencies. And to declare that vulnerable young people who are contemplating suicide are incompetent as a matter of law and therefore are entitled to special rules is completely contrary to both precedent and to the purpose of the Washington Product Liability Act, which was to delineate the substantive liabilities of manufacturers and sellers, because there was a insurance liability crisis that came from the urge for courts to always use either common law negligence or strict liability to try and remedy every harm that they saw arising from a product. And the legislature said, we're going to step in, we are going to preempt the field. And they give you the purpose of the act in the text that is adopted and passed by the legislature. We are going to balance, we're looking to reduce exposure to product liability while reserving the right to recover for injuries that arise from an unsafe product. That does not extend to obvious misuse of the product. And I think most importantly here is whatever issues you might have with other duties that sellers have, what we're talking about is holding sellers liable for the intentional conduct of a third party that they do not have a special relationship with. And we point in our reply brief that the statutory definition of fault does not include intentional acts. There is no way to attribute the respective liability between a claimant and a defendant under a negligence-based action if there's an intentional act involved. And so, quite frankly, it just doesn't fit. And that's why in the special relationship context, the Supreme Court in Gregoire had to create all sorts of different rules and remove most of the normal defenses, or otherwise there would be no duty. They said it would gut the duty if we applied normal assumption of the risk.
Counsel, does in the few moments you have left, does the CPA claim in the Vickless and Passananti complaint survive independently? Absolutely not. I mean, I think what I've learned in briefing against appellate counsel is you always look for the arguments that they don't respond to. And we point out that under Ambach, you have to identify two separate courses of conduct. One course of conduct that causes the economic injury and a separate course of conduct that causes the physical injury.
Well, in
And they
Ambach,
simply cannot
in
do that.
Ambach, they only alleged professional negligence and they didn't allege entrepreneurial deceit, right? That was the problem in that case, is there never was any kind of entrepreneurial claim that was alleged. Everything just sort of depended on the professional breach of duty. And if you look at lifestyle, which is a little bit different, you have an allegation of entrepreneurial issues and an allegation of professional liability, professional misconduct, and that was okay. And the injury was the price paid for the cosmetic surgery in that case. Why isn't this case more of a causation issue than it is an Ambach issue?
Okay, so to the entrepreneur, that's the special rules that doctors, there are certain carve-outs there, but the marketing about the newness of the surgery and the convenience was separate from the representations about safety. And they don't deny that the core concern of Ambach of allowing someone to bring a WCPA claim every time there is a failure to warn issue is still present here. And finally, I'll say is, if the failure to warn claim goes on proximate cause, all the other claims do as well, because legally the responsibility falls on the claimants. And if you want to change those bedrock rules, the proper course for that is through the legislature, as California and other states have already addressed.
Thank you.
The next case will be Harder versus Seattle.